Hey, good morning, Jeremy.
Hey, Brian.
A friend of mine, I know people are listening, but it's fine. A friend of mine plays on Facebook. I see he plays like nightly dress up, like theme things. Like he dressed up like a punker last night. It's just funny stuff that he posts. So I decided I'd dress up for work today, even though I'm home.
Hello, gentlemen.
Adam,
Good morning.
we'll get started right on time for the attendees. I see we're still populating. We've got maybe a third of the expected attendees. We'll start right on time, but by the time we get to the meat of things, I'm sure most people will be on.
Should be another great one. The Three Musketeers ride again.
Absolutely.
They're lucky to have us. Right, Jeremy? Right, Brian?
Absolutely.
Of course.
I was very excited when I saw the list this morning. I was like, oh, look at all the people who signed up through my link.
I mean, you're much more successful at it than me.
Well, I do my best. I just try to carry my share of the load. I actually didn't get to put it on all the LinkedIn groups I wanted to, so it might have been even more, but that's okay.
Oh, I neglected that as well. Oh, well.
I think we were a little busy doing other things.
Yes.
Cecilia, who works for me, says we are lucky to have you guys. I'm lucky to have you too.
All right. So we're right at noon. So thank you all that are in. I see that we have maybe about half or so of the people that are registered are on. We're going to go and get started by the time that we get to the meat of things anyway. I think most people that are lagging a few minutes will be signed in. So first, thank you for attending this afternoon, which is just now afternoon. We're eager, as you can tell from our kind of back and forth. We're eager to share ideas with you. Kind of part two, responding to the coronavirus, be practical, stay legal. So this is scheduled for an hour. It has been approved for one SHRM, and it's no longer pending. It's been approved for one HRCI credit. So we have both of those. I have the certs. I'll email those later this afternoon to all the attendees. So just be a little patient. There's a lot going on. You'll get them, no later than early evening from me. Directly. So our agenda, much like last week, I'll provide some brief bios, then share some high-level insurance updates. Adam and Jeremy then we'll each provide insight into kind of in-depth insight into a few topics based on their expertise. And then kind of in difference to last time, we're going to kind of jump into Q&A, I think, whether it's us kind of asking questions of each other or you asking questions of us. We found that there was a lot of overtime last week because there's a big appetite. There's a lot of information that's coming out. It changes, by the day, sometimes by the hour. So we want to be flexible, and we've budgeted time for overtime. There's a couple different ways. I'm a bit better at the platform this week. By the way, this will be available. You'll get a link so you can see this in the file versus my kind of my YouTube hack that I had to do. No rookie mistakes this time. I'm a little better. So you'll get that link. You'll get those certs, all that'll come out this afternoon. So just kind of jumping in, just some intros. My name is Brian Klickner. I'm with Risk Strategies. I've worked as an insurance broker and consultant for over a decade. I've also got an additional 5 or so years of experience with a Virginia-based government contractor. I was kind of the Swiss Army knife there, reporting to the CEO. Here at Risk Strategies, my team and I, we work with clients to create bespoke employee benefit programs. Whether you're a small group, 25 to 50, or we have a lot of clients in that 500,000, even 1,500 plus space. Whether it's digital enrollment, custom mobile app enabled employee advocacy that helps with healthcare experience management, direct contracts with hospital systems and physicians, to removing kind of the big 4 insurance carriers from the equation, which seems daunting, but we're doing that for our clients today. That can help a lot with client experience as well as cost mitigation. So Adam Calli. Adam is a 20-plus year veteran and the principal consultant and founder of Arch Human Capital LLC, which focuses on helping organizations reap the rewards of the promise of a modern HR while meeting their compliance mandates. Primarily focusing on small and mid-sized businesses, he enjoys seeing how well-run HR can have a positive strategic impact on your company. When not consulting, he's an HR instructor with George Mason University's Executive and Professional Education Program and is one of only 41 active instructors nationwide for the Society of Human Resources Management, or SHARP. Jeremy Schneider. Jeremy is a labor and employment attorney here in the Washington, D.C. Regional Office of Jackson Lewis, PC. He represents employers in a wide variety or wide array of employment, non-compete, and whistleblower litigation. And Jeremy also provides advice and training to management to help employers avoid that litigation, which is key. So, quick insurance update. The coronavirus outbreak is a rapidly evolving situation that presents both health and business risks on a global scale. As our clients work to respond to the pandemic and deploy business continuity plans, we're working to monitoring developments worldwide. Our team of risk advisors and brokers is prepared to help minimize the physical, financial, and reputational losses that businesses might face as a result of the virus. That's kind of what we're here to help you with, the three of us. In addition to keeping workforces safe, our focus is on serving clients during this time by assessing their risk and analyzing coverages to determine if their losses are covered. So a couple things. One is a little out of my lane, but this came from our national office, and I wanted to share this piece. So cyber risk. So this event is causing cyber criminals to be very opportunistic and preying on our fears. So cybersecurity experts have warned in recent weeks that they've seen a tremendous spike in the number of phishing emails that are related to coronavirus or COVID-19. We recommend that you review your organization's current cyber policy to make sure that system failure business interruption coverage is included. When reviewing your current policy, make sure that there is no exclusion around communicable disease or any language around requirements to maintain adequate bandwidth to sustain operations. So on that note, just talk to your commercial insurance specialist that you're working with to kind of better understand your cyber risk. An update on dependent care FSA. So this is a challenge. So the pandemic can be considered a qualifying event to allow employees to change their elections for dependent care FSA benefits. Really, the standard qualifying events for dependent care allow for a change to the election anytime there is a change to the dependent care provider or a change in the number of hours of care needed. So this obviously impacts that, whether it's a matter of you don't have access to childcare or you have a larger need for it and can actually utilize childcare services now where maybe you didn't need them before because of this situation. They are available. So I'll provide a link to this in the follow-up. Health insurance, testing and testing related services. There's not a big update here from last week. The testing itself is covered on fully insured plans. The documents have been amended so that there won't be a cost share associated. Plans need to be amended, so you need to amend both your medical SPD and your stop loss contract to make that so it's not a cost to the employee that goes and utilizes those services. Just as of yesterday, on our team call this morning, I became aware that United Healthcare, fully insured, is allowing a special enrollment period for small groups and their large group employers on their fully insured platform. So if you're one of those employers, then you probably are going to get some communication, but reach out to your insurance professional for more details. At a high level, from March 23rd to April 6th, they're allowing a special enrollment for employees who previously did not elect to enroll. So this is only applicable for those employees. This isn't an opportunity where your current enrolled employees can move plans. It's specifically related to allowing non-enrolled employees to enroll in the plan. So talk to your insurance professional on that. Disability and coverage, which is you're gonna see more information on this or more need for this. So carriers are addressing quarantine in different ways, and most of them are addressing it in a pretty standard way. So you'll want to talk to your insurance person about what's the definition of disability, what's the definition of sickness, are there any exclusions? Do you have an embedded employee assistance program? If so, have you communicated that out to your employees? Specifically related to quarantine benefits, I've only come across one carrier so far specifically that actually has a rider that's standard on their newer contracts. and they have some kind of the basic language. It looks like, the quarantine rider covers employees if they are placed under a doctor ordered quarantine and are unable to perform the major duties of their job. So, it's kind of couching that language. It's a little more aggressive than what you see your typical short-term disability plan, which basically defines it as your inability to perform the material and substantial duties of your job. So there's some language there. Talk to your insurance professional. Most are just treating it as any other disease. So that's that. I have some pieces which I'm going to defer on because I believe Jeremy's going to go into some depth about furloughs, if I'm correct. So I'll defer and kind of supplement what he's talking about on a benefits perspective later. With that, I think before I hand it over to Adam, we wanted to find this. We have a poll that we want to run just to give everybody kind of a better understanding of the size of your companies. This will help Adam and Jeremy and myself kind of better communicate what's going on. And you guys are rapid fire and just killing it on turning this over fast. So we're about halfway through the number of respondents. So I appreciate that. And it is a wide spectrum. I'll share the results here in a minute. But we do appreciate your being engaged. This is the only poll that we actually have planned. Other than that, we're going to get in to some details. We're kind of slowing down. Let's see. Well, I do have one question. Let's see. I missed what was said about the qualifying event. Can that be repeated? Absolutely. I will come back to this. Let me just close this poll. End polling. I'm going to share the results. And while we're looking at that, before I hand it over to Adam, so this is related to I believe you're asking about qualifying to dependent care. So anytime you have a material change in the employee has a material change in the need for childcare, whether it's hours, they need to increase or decrease in some way, shape, or form, that's considered a qualifying event for a dependent care FSA. We're still pending some insight into medical FSAs and how those are working. We have some preliminary guidance that I'm not in a position to share today, but I'll provide some more detailed guidance on that. If Adam or Jeremy, you have specifics, dive right in on that when you're getting into what you're talking about. So I think that answers the question. So what I will go ahead and do is, I think everyone sees those results.
Yep.
All right, perfect. I'm going to go ahead and I'm going to stop my share of the results, and I'm going to hand it over to Adam to kind of dive into your core topics. Thanks so much.
Well, hello, everybody, and either welcome back if you joined us for the first session, or welcome to this second session. I do have some slides I'll be sharing. We've got a lot of ground to cover. We will be covering it quick. As Brian said, it is a recorded session, so you can always come back to the recording and check anything if we happen to move a little fast on that. So here we go. I do want to let you know that Jeremy and Brian and I, as the Three Musketeers, are up for the Oscar for the Best COVID 2019 webinar. We hope that you will definitely agree with that. But as they say, even if you don't win, it's just an honor to be nominated, right? So 15 days ago, I participated in a webinar that SHRM co-presented with the CDC, and this gentleman, Dr. Jay Butler, Deputy Director of Infectious Diseases, said the coronavirus will impact all of society. I wrote that down as I was listening to him. And here we are, 15 days later, how much things have changed. I even saw something interesting about funeral homes, right? Not an industry that's probably represented on this webinar, not an industry many of us tend to think about, but they've had to make changes, like only allowing immediate family when they're conducting services, live streaming services for those who can't attend, separating attendees into different rooms, different groups, in order to practice social distancing. So you think you've got it tough. Imagine if you were in that field, right? But the good news is, at least, you're not. Be that as it may, there's a lot going on right now, and there's a lot of information out there. This article was in Business Insider on Friday, and it very much focused on layoffs and furloughs. Obviously, it's an article from Business Insider, a reputable magazine, a reputable publication. There is a bit.ly link here. I will tell you I'm quoted in the article. It's a nice introduction to a lot of topics. If you find yourself needing more information, that's an opportunity to engage with your employment attorney. or your HR consultant, or at least have your HR person do some Googling. Should you find yourself thinking about these furloughs, these layoffs, and considering severance, there's another article that I would point you towards. It was from HR Magazine. It was actually last June, July of 2017, but a lot of very valuable info, a lot of smart people quoted in there. I like to consider myself one of them. So if you're contemplating approaching your layoffs with some severance involved, I would encourage you to take a look at that and see what you might learn. Now, as we're talking about furloughs and layoffs, we might also be talking about how do we keep the company afloat? Let's consider wage cuts. That's fine. Bonus cuts. That's fine. Obviously, both of them are not preferable, very unpleasant. But as you contemplate them, I want to remind you of what happened January 1st of this year. Any of your exempt employees, in order to be exempt, must be paid a minimum salary, among some other factors we're not going into right now. What I want to point out to you is that as of January 1st, your folks must make $35,568 a year, or $684 per week. So if you're contemplating a wage cut for folks on the lower end of the spectrum, remember that is the floor beyond which they would lose their exempt classification. Another new thing that came out with this law in January, long before we were thinking about the coronavirus, was the fact that up to 10% of their pay can be made up by non-discretionary bonuses. Non-discretionary, key word there, okay? So again, if you think, hey, you know what, let's just not pay people bonuses right now. We're trying to keep the company afloat. We want to continue to employ as many people as we can. I admire that. It's a very practical approach. But if you're doing that, remember, there could be an adverse impact on, again, some of the people at the lower end of your pay band below the minimum. So more for you to consider. One more law. There are still some of you out there who are hiring. And it is important to note that if you are hiring, but you're not doing in-person orientations as you traditionally do, whether it's because of social distancing or people's inability to travel, there were some I-9 changes that were announced last Friday. Now this is funny because last Wednesday we did our first webinar, and at that time we told you you still have to review the documents that are provided in person to prove identity and right to work in the United States. 48 hours later, it had changed. So if you guys think things are changing fast, the only thing I can do here is quote my pal Bruno Mars from his great song 24 Karat Magic, which says, keep up. So if you know that song, hopefully you get the joke, and if you don't, you get the message anyway. Keep up. Things are moving fast. The three of us spend a lot of time reading, a lot of time collaborating, and the best I can tell you is keep up. Now, with that said, let me talk about this change for the I-9. Again, it is temporary. It is in effect for 60 days, and it was in effect as of the 20th of March. You can do this, but if you do it, you got to tell your folks, as it says on the screen, provide written documentation that we are doing remote onboarding, and we have a telework policy in place as a result of COVID-19 for the foreseeable future. Understand you still have to review their documents. However, you can take a scan and let them email it. They could take a picture on their phone and send that to you, text it, email it. They can hold it up on the screen and allow you to view it. Those are the temporarily allowed approaches. Okay, you still have to review it and quote unquote inspect it and retain the copies, assuming that your organization has elected to retain copies. And if you haven't, then that's fine. You want to be consistent. But that said, when you fill out the I-9, you still got to do the I-9 on time. It's just the ID that you're receiving later. And as you'll see, this is a picture, an excerpt of the current I-9. By the way, I hope you all are using the new one that went into effect not too long ago, just earlier this year. And if you're not using the right I-9, well, that's a whole nother topic. We're not going to get too deep. But what I want you to know is, as it says here in the additional information box, we have got this great big yellow arrow. You need to write COVID-19. And then when you do finally physically review the documents, you must write documents physically examined with the date. And obviously I put 2020 because this is only going to be good for 60 days as of this point, okay? So this only applies to people you're hiring if you happen to still be hiring over the course of the next 60 days, all right? So make sure you're doing your I-9 right. We don't want any I-9 fines. Now, when your normal operations are back in business, anybody that you remotely onboarded, they've got those 3 business days to provide you their documents in person, the same as you would do at time of hire. So we're all used to that. It's just going to be delayed. And again, once the documents are inspected, you make the note, as I pointed out in the prior slide. It only applies to employers and workplaces that are operating remotely. So if you're still business as usual, you don't do this. You hire a new employee. I was speaking to one of my clients last night. She said they have 2 employees expected to hire on before the end of April. That company is in the government contracting space. Their employees are coming to work because they're considered essential. So in her case, she would do the I-9 with them the same way as always because there is no social distancing and separation. So you know where you fit, keep that in mind. Now, if we're talking about the I-9, you might think, should we talk about E-Verify? And if you thought that, you're right, because there's also been a temporary adjustment under E-Verify. And I provided the link here so you can read this yourself. But in a nutshell, it says, we have extended the amount of time that is available to you to resolve the tentative non-confirmations. If you don't use E-Verify, we'll just move on to the next slide. If you do use E-Verify, now I've made you aware of it, you can read the additional details on your own. Now, many of us are in the DC metro area, and as a result, you may have employees working in DC. So I'm going to give you a little look into my crystal ball for a moment. I said this last week, and I'm saying it again. I'm just like you. I don't have any special access to the White House. I don't have any special access to the CDC. All I know is what I read. But as of last week, I've been advising my clients, based on my assessment, to expect this to last to somewhere between June and August. And if you want to split the difference, that means July. And I will tell you, I hope I'm wrong. I would be thrilled if Brian and Jeremy were able to say to me, hey, Adam, you were wrong. But I'm advising my clients, plan for this to last a while. And if it does end up lasting a while, and if you have employees in DC, and this is not a session about the DC Paid Family Leave Act, but that takes effect July 1st, right in the middle of the time frame that I'm advising you. And again, we're not diving into detail, but what I want to mention that is relevant to the coronavirus is that you would be eligible for 2 paid weeks of personal medical leave or 6 paid weeks of family medical leave, assuming you're caring for a sick family member. We're not going into the definitions of family members. We're not talking about the cap on the pay. All of that may not even be an issue, assuming we're out the other side of this mess by then. And even if we're not, as it gets closer, the details are out there for you. But I want to keep that on your radar screen, because if I'm right, and if the experts are right, and we don't wrap this up to the summer, it is possible that those who get sick late in the game may be eligible, again, assuming that they're a DC worker. Now, last Wednesday, there was the Families First Coronavirus Response Act came out, and we were told that within 7 days of passage, we would see a new labor poster. I was looking for it this morning, and it's not out yet. And you'll see, I gave you the link to the DOL website, and it says, each covered employer must post in a conspicuous place on its premises a notice of the requirements. And in the footnote, it explained they will have it no later than March 25th, which is today. So will it be out by the end of the day? Your guess is as good as mine. If it is, great. If it takes another day or two, so be it. The law doesn't take effect until April 1st. But when it comes out, it's just treated like all your other labor posters. So you hang them where you hang the other ones, and you distribute them online, and you put them in your intranet. The things you do with every other labor poster, do with this one. But keep your eyes peeled, because it should be out kind of at any moment, if you will. Jeremy, of course, will be digging deeper into this, but I just wanted to kind of cover that one little aspect of it. Now, many companies over the last 15 years or so have switched from having separate sick and vacation time to having combined PTO. Okay, that's great. But now we've got a very special circumstance on our hands. And here's what I want you to think about. Under the Families First Coronavirus Response Act, you are eligible to get refundable tax credits from the government to help you be able to afford to pay your employees when they're out for one of the 6 covered reasons. And again, we'll get into that shortly. And of course, you've got to pay that money. How do you justify that it was spent? And here's the advice that I've been giving. And you can do whatever you want. But my advice is to create 2 timekeeping or earnings codes. Maybe your timekeeping system feeds into your payroll system. That's a logistical issue. We're not going to get into that on this webinar. But theoretically, you create 2 codes. I'm calling them COVID-19 personal and COVID-19 family. And the reason I suggest you have 2 codes is because they're paid at different rates. One is paid at a certain amount of time at your regular rate, capped at $511 a day. The other one is paid at 2/3 of your regular rate, capped at $200 a day for a certain period of time. If you just have your general PTO bucket that you've always used, and people record time out for one of the 6 coronavirus allowed reasons, how are you going to distinguish that from somebody who just took time off because they went to the beach, not that the beaches are open, or because they had kidney stones or something? You want to be able to justify to the government, if you're audited, these people used this leave, this was the cost, and as a result, we used that basis for our tax refunds. So that's a little practical advice there for you. You should be working with your payroll company. Some companies are better than others, so you may need to prod them. Don't rely on them. That's not an excuse. A little bit of free advice. Almost done here before I pass it over. So we were discussing last week, but we wanted to get back into it. What about employees who can't telework? And this is one of the favorite cartoons that I've uncovered. This is your pilot speaking. I'm working from home today. So yeah, wouldn't that make you feel great, right? So what do you do if you are in a situation where telework is not an option? Well, I will tell you, I was speaking to another client this morning. They're in the plumbing business, and they are actually paying their employees who they don't have work for 50% of their pay to stay home. Now they're talking about non-exempt employees, so we're not worried about exempt justification. And you know, hey, at least as long as they're getting paid minimum wage, better to get something to sit at home than nothing at all. And of course, it still maintains their employment. And obviously, the company is trying to do right by their people, which of course I admire. So there's a lot of situations out there where people may not be able to telework. And again, some of these things I went through last week. Think for opportunities for maintenance and cleaning and upgrades. What kind of installations can you do? What kind of beautification projects can you do? The client this morning was talking about, we're installing new lighting in the building and in the front of the building because they've got people available, and you know, that's great, right? Why not? Community service can be great. There's a lot of need out there right now. And many companies pay people as a benefit, will pay a couple days a year for people to do community service. This might be a time to roll that benefit out if you like it. Staggered shifts can be effective. Okay, admittedly, not everybody's still going to be at work, but at least some people will be at work. It enables the social distancing, and it prevents people from losing all of their income. Now, it's always good to try to get ideas from other sources, and Hilton Hotels is being affected by this just like every other aspect of the travel industry. And Hilton actually created a workforce resource center. They are helping their current employees, good quality folks, to get jobs with Albertsons, CVS, and a variety of other organizations, other grocery stores, etc., who are right now very busy. They got drivers that are running like crazy to keep stores stocked, right? They got to maintain the supply chain. So I know you're not Hilton. You may not be able to do what Hilton can do, but this is a time for adaptability, flexibility, and creativity. That's an example of what they did. Maybe you can find another organization in your community that needs the help, who's looking for people, and encourage your people to go work there temporarily, of course, in the hopes that they'll come back afterwards. But we're just trying to take care of folks at this time. And the last slide that I have before I hand it over, this actually came from my CPA, trying to give me, as his client, some advice. So the IRS has provided guidance on how these tax credits are going to work. Because for you smaller organizations, we saw on the poll that Brian ran, how many smaller companies we have out there, many of you under 500, you've got to give this paid time off. How are you going to afford to do it? If your people aren't working, they're not generating revenue. Maybe you can tap into a line of credit. Maybe you can look for some alternative lending. But what the government's trying to do is say, okay, instead of paying the payroll taxes you would have to pay, we're going to let you immediately offset the amount that would be payable by the amount that you've already paid to people using one of the 6 reasons of being paid for one of the 6 reasons under the Coronavirus Response Act. And in the event that your bill is less than the amount you've paid out, your tax bill that is, they are working to expedite payments to employers within 2 weeks of filing. Now, I am not your tax guy. There's no tax person on this webinar, so I'm just passing along what my tax guy shared with me. But the information is out there. So as you're contemplating layoffs and furloughs and wage cuts and all those other unpleasant things, some of them may not be necessary, or you may not have to take as drastic steps if you're able to make sure that that money is flowing back to you from the government subsidies. So at this point, I am going to stop sharing my slides, and we're going to pass it over to my good buddy, Jeremy.
Thanks, Adam. So I hope everybody is doing well. Obviously, Adam's right. Keeping up is tough right now. We're having a lot of things happen every single day. In fact, the main thing that I want to talk about in my piece before we get to your questions is the new law, which we answered some questions about, but in typical lawyer fashion last week, I said, well, it depends on what the final bill looks like, and that might change, and there are some things that could or could not be in the new law. And so actually the night after, or the night of last Wednesday, when we conducted our webinar, the Senate passed and the president signed into law the Family's First Coronavirus Response Act. And the final bill did, as we thought, differ somewhat from the House bill. And so what I want to kind of focus on is what the law requires, when it goes into effect, and then some of the kind of advice points that I'm giving our clients as they're calling me. And so I think first, the gist of the law is the same. It expands FMLA to include COVID-19 related illnesses or obligations due to caring for someone with an illness. It also provides for paid sick leave for COVID-19 related illnesses or pay, obligations for caring for someone with a COVID-19 related illness. At the same time, the big game changer we talked about last week is this issue of leave for when schools are closed. And so I'm going to kind of go through what is going on right now, and we'll kind of just go through from there. And if you have any questions as we go along, feel free to put them through in the chat. We can either take them as we go, or we can take them at the end. So
we do have,
first,
no,
go ahead. Go ahead.
But I think it's just, so there's a question that says, does this apply to employees under, employers under 50 employees?
So yes, right now it does. Now, what the law says is that the Department of Labor can issue regulations exempting employers of 50 employees or less if doing so will, if for individual employers, if exempting them will sort of alleviate, an extreme financial burden. So one thing I was going to get to, but I'll kind of go to it right now. The Department of Labor issued yesterday, I believe, some FAQs, and I'm going to try to share my screen, and we'll go to that. We will go to that. So hold on one second. Let me just share my screen. Okay, can everybody see this? So this is the Department of Labor's FAQs that they issued yesterday about the Family First Coronavirus Response Act. And if we go down here and we look at number 4, if providing childcare-related paid sick leave and expanded family and medical leave at my business with fewer than 50 employees would jeopardize the viability of my business as a going concern, how do I take advantage of the small business exemption? And the Department of Labor says that to elect this exemption, you should document why your business with fewer than 50 employees meets the criteria set forth by the department, which will be addressed in more detail in forthcoming regulations. Those regulations have not been issued yet. But I expect in the next couple days that they will be, given that this law goes into effect on April 1st. So we're hopeful that the DOL puts out some regulations in the next week that cover this. The DOL does say that you should not send any materials to the DOL when seeking small business exemption for paid sick leave and expanded family and medical leave. Now, that is really, I think, a temporary thing. These FAQs will likely change on April 1st. So when that guidance comes out, it will speak to this issue. So there is some potential for relief for very small employers for the financial burden associated with this. Now, again, as Adam said, there are sort of tax ways that the government is trying to alleviate the burden of this as well. So whatever you pay, you can withhold on your payroll taxes as paid. So it's sort of on a rolling basis, right? And then there's a credit for that at the end of the year as well. So you're going to look at all those things and kind of weigh out what you're going to happen. But the real kind of, hot button issue under all of this is that this law covers employees who are home, who have to be home because their child's school is closed. And so as a result of the medical emergency that we're under right now, which really does cover almost every parent and student in the country right now, there are very few places where schools are just not operational. In fact, I'm not aware of any, although I did read that Liberty University is asking their students to come back in the next couple weeks, which kind of flies in the face of conventional wisdom across the country. So that's where this issue is really a big deal. Let me stop the share. And I just want to kind of go back generally. We've got that one question. I would like to go back generally and just chat a little bit more about what the final bill, requires. So we're talking about, again, we mentioned this last time, we're talking about the paid FMLA and paid sick provisions apply to private employers with fewer than 500 employees and then certain public employers. Both of those provisions, the FMLA and the paid sick leave provisions, allow an employer or allow subsequent DOL regulations, which we talked about. They also amend the FMLA to allow an employee who is unable to work or telework to take leave due to the need to care for the employee's son or daughter under 18 years of age if the child's elementary school or place of care has been closed. So this also would cover daycare institutions as well. And unlike the original bill, which we discussed last week, the closure of the child's school or child care is the only reason allowed under the added FMLA provisions and the only reason allowed for paid leave under the FMLA. So that's a change. It isn't as expansive as originally wrote. On the paid sick leave bit, the Act adds a paid sick leave obligation. So employers with 500 or fewer employees must make immediately available 80 hours of paid sick leave for full-time employees, or the equivalent of the average number of hours over a 2-week period for part-time employees, for the following reasons, which are slightly different than the original bill. So the first reason is the employee is subject to federal, state, local quarantine as related to COVID-19. The employee has been advised by a healthcare provider to self-quarantine. The employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. So the diagnosis doesn't have to be official yet, but seeking the diagnosis. The employee is caring for an individual who's subject to an order as described above, or has been advised as described above. So a child who is who you are seeking a diagnosis on behalf of, or a child who is also subject to quarantine as a result of COVID. And then fifth, the employee is caring for their son or daughter if the school, place, or place of care, or school or place of care, or of the son or daughter has been closed. And then the sixth bit is the employee is experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and Secretary of Labor. That bit is kind of a catch-all. It's to allow a little bit more flexibility in terms of symptomatically what you're feeling or what a potential diagnosis might be, or whether there's a public health risk that could evolve out of this situation. That's how we're kind of reading that, although there hasn't been guidance on that. Under the FMLA provision, when leave is needed to care for a school closure, the employer can provide the first 10 days of leave unpaid. Then subsequent absences for this reason must be paid at 2/3 the employer's regular rate of pay. Now, the act includes a cap of $200 a day and $10,000 in aggregate. Also, if the first 10 days are unpaid, an employee can elect to substitute any accrued vacation leave, personal leave, or medical or sick leave for that period. Paid sick leave is paid at the employee's regular rate for a use described in paragraph 1, 2, or 3, which is the diagnosis piece, and 2/3 of an employee's regular rate for the use described in 4, 5, or 6, which is the school closure bit. Paid sick leave is also capped, $511 a day and $5,110 in the aggregate for the uses described in 1, 2, or 3, which is the diagnosis. You're actually sick, you get paid. And then $200 per day cap with $2,000 in aggregate for the school closure provisions of the law. The effective date, it goes into effect no later than 15 days after enactment. And so by my calculation, I believe that's April, 14 days would be April 1st. I think the DOL's FAQ says April 1st. So we're just gonna go with that. We talked about job leave being protected. We talked about this last week. So yes, the job leave is protected. However, the FMLA's requirement that an employee be restored to the same or equivalent position after the leave doesn't apply to an employer with fewer than 25 employees if the employee's position no longer exists due to the economic conditions or other changes in the employer's operation that are caused by the public health crisis. So there's a sort of a limited protection there and a limited exemption for small employers under 25 who have to eliminate positions as a result of the crisis. Now, the law, again, vaguely, and I'm not really sure how this plays out, but there may be regulations on it. The law also says that employers have to make, quote, reasonable efforts to restore the employee to the same or equivalent position. And if those efforts fail, the employee must make efforts to contact the employee and reinstate them in an equivalent position, if an equivalent position comes available within a year after the date of qualifying need, or the date that's 12 weeks after the date of employment, of the employee's leave starting, I'm sorry. Who pays? We had this question last week for new people. Who pays? It's the employer who pays. So although there's offsets. So we've talked about that. We also got the question last week, is this paid sick leave in addition to current leave? And the answer to that is sort of. So Congress removed the provision in the original bill that would have prevented employers from changing their current policies and benefits in response to the act. Okay, so they took that bit out. They want to make sure that we're not gaming the system in the days leading up. But an employer can't require an employee to use other paid leave provided by the employer before the employee uses paid sick leave available under the act. Those are kind of the big pieces. One other thing that I'll mention that we talked about last week, which is a huge change with how a lot of us or all of us have dealt with the FMLA in the past, is that to be eligible for these benefits, somebody doesn't have to be an employee for a year or 1,250, or I've worked 1,250 hours. What now is required is only 30 days. And so that's a big deal. Your new employees are eligible for this leave, and that normal calculus just does not really come into play here. Oh, I've had another thing I'll mention, I've had a lot of clients ask me about how do we calculate whether or not we're under 500. So I saw in the poll, there's not a whole lot of us that are over 500, right? I don't remember the exact number, but I recall about half of the responders being in the 26 to 500 range or something like that. And so if what the advice that we're giving our clients is, and one of the FAQs addresses this, so if you want the link to the DWELS FAQs, I'm happy to provide it in the chat or if you contact me. We're telling our clients, don't take a position. Normally, you're trying to avoid, if you've got a subsidiary or a parent company or related entities, oftentimes what happens in litigation is plaintiffs sue everyone. Any company that's possibly could be related to the real employer, they sue. And in those litigations, counsel and companies typically take the position that they're not joint employers, that there are separate entities and there's only liability for one entity. So what we're telling clients now is, it doesn't really make a whole lot of sense now to take a position where you're trying to gobble up all the entities in order to get over 500 to exempt yourself, because it's likely that if a suit was brought for violating these laws, that the DOL or a court would take the position, they would look at those prior positions that you've taken in litigation in the past, and they would say, look, you can't take a position now to kind of, for lack of a better word, avoid having to provide this benefit. That wouldn't be permissible. And so we're talking to our clients about that. And so if you're squarely under a 500, it looks like this applies to you, absent the exclusion for employers that are less than 50. And we are advising our companies not to start combining their entities in order to get over 500, because it's going to be tough to show later. And so that was my spiel about it. Happy to take specific questions about the law. I think there will be a lot. There's a lot to unpack here, and there's a lot of nuance. So, Brian, I don't know if you want to.
Yeah, what I'll do, I've got a series, I've got 6 or so questions in the Q&A, and it looks like, 4 to 5 things sitting in the chat. So before I jump into those, and I'll just ask those questions and you guys can respond. So I think most of them are going to be related into areas where you can have more expertise. I want to jump back, kind of referenced furloughs earlier,
Yep.
A little bit about that. So some updates. So from a fully insured perspective, what we're seeing, the carriers are allowing furloughed employees to stay eligible if premiums are paid in full. So that's a help. So anybody that has a fully insured plan, it's pretty much easy as long as the premiums are paid. Now the challenge you're probably going to run into is where the premiums coming from. What we're seeing our clients doing is they're just paying the premiums in full themselves from the company's perspective if they're having to furlough those employees. Self-insured allows the same thing, but you have to amend your plan documents to do so. So whether it's your plan description or your stop loss contract, you need to make sure those documents are updated. So talk to your insurance professional, and from a self-insured perspective, you can do that. And that can be even small employers. I mean, you might be a 50-person shop and have a self-insured plan. So just have a conversation with your consultant on that. Kind of these practical considerations. Just some things that we're seeing some of our clients implementing, and these are from a range of different types of services, not your GovCons per se, but this is home services, event lighting, construction services, some strategies that they're at least discussing or in the process of deploying to their clients. Companies, like I said, 100% of the premium for furloughed employees are setting durations of say 2 months as kind of their benchmark for this. Some companies are actually terminating some of their ancillary benefits, like their dental and their vision, in order to conserve expenses, because they want to be able to hold on to the health insurance for their employees. That's key, obviously, in this particular situation. Casual or non-benefit eligible employees typically aren't furloughed. We're seeing those just being terminated. Point to Adam on that. There are a lot of hires going out there. Hilton is a good example of that. Logistics, delivery, food services, these types of companies are hiring a lot of people. So, and then we've seen clients actually institute across the board, 20%, pay cuts. I know we talked about this last week about kind of grading that, having those discussions now. We're seeing that get involved currently. Now, when we see that, the employer is then picking up a larger portion of the health premium. So if they're moving all these levers, they're just trying to stay alive, basically, and they're having detailed conversations with their employer. So with that, I think that was just a couple of things on furloughs and kind of practical applications that we're seeing with our client base. I'll jump in and kind of go through from the first questions that I started receiving, and you guys can kind of answer in rapid fire. And we probably will get into overtime. So for those that are here specifically for the CEs, which I think those are good ancillary benefits. If you have to leave, you have to leave. Don't worry about that. You're going to get your certificates. I'll get those out this afternoon, like I mentioned. So the first one I have here, say if you have employees that have more than one job, does the part-time job or the secondary job have to give the employee paid sick leave?
Okay. So, all right, I'll take the first swing at that. Obviously, this is evolving. It looks like what the Department of Labor is doing is saying all full-time employees are eligible for this. And the amount that you're allowed to give them in terms of paid leave hinges upon that. When you're talking about part-time employees, now this is as a separate, sounds like you've got a person who works full-time for you and then has another role that he works part-time. Is that he or she? Is that the question? I just want to make sure I'm clear about that.
Yeah, if you can.
I think you said something about two roles. That's what trip. So for part-time employees, you can go back and look at the average number of hours worked over a 2-week period. Now, again, I'm going to look at the FAQs myself because there is an FAQ in the Department of Labor's recently issued FAQs that talks about calculating pay due to employees and whether overtime hours are included. So I just want to take a look at that real quick. But Adam, if you want to weigh in, let me just see if I can find that answer specifically.
Sure. My interpretation of the question was, let's say somebody worked full-time for me and had a part-time job at another company, or in reverse, had a full-time job at another company, a part-time job with me. And the question would be, if we know our employee has 2 jobs, one with us and one somewhere else, do we have to pay? And my interpretation of that is, a lot of people have more than one job because they need it to make ends meet, right? That's why they have 2 jobs, whether it's 2 full or 1 full apart, whatever, right? Maybe even 2 part-times to make the living of 1 full-time job. And so if they are eligible, employed by you more than 30 days, they're eligible. You're under 500 employees, you're mandated. So I didn't read anything that said you don't have to take into account other employment. They work for you, look at it in tunnel vision, do what the law says relative to their employment status and their earnings with you. That's my interpretation of the question relative to my understanding of the law. Happy to readdress if that's not correct. But
I agree with that. So normally when we get questions that are like that, and you're asking whether or not certain laws apply to you or not, the answer is usually look at the definition of employer under the law. And most of these laws, including this one, define employer to be very broad, meaning any business or entity that employs another person. I mean, that's really as simple as it gets. So if you have an employee who is full-time or part-time, regardless of what their other employment is, I think you have to give them whatever benefit they're entitled to under this law. Certainly the Department of Labor, the first question that they would say to you if they came in to conduct an investigation would be, well, why do you know or care about what this person does in the other 16 hours that they're not with you? And so I would evaluate it on an employee basis with regard to whether you actually employ them, not whether you know other circumstances about it. Now, an employee uses, let's say there's a part-time employee who's using their leave from their other employer, which also means that they're not coming into work for you. That's an issue that I think you could mitigate, you could manage, you could discipline for perhaps if it's not protected leave for you. These people like FMLA, I mean, somebody has to take the leave in order to get the protection or ask for the protected leave, right? And if they're not asking you for the protected leave, or they're not telling you these things and you don't know, or you do know, but they're not doing it through you, you might have some options. I wouldn't say go ahead and fire them right away. I would want to walk you through it, but that's something to think about.
Okay, so got a question in the chat. Says, is it okay to ask employees if they have COVID-19 in order to be able to categorize the sick leave correctly? I have 2 employees currently out with fevers, albeit the law doesn't kick in until April.
Right. Okay. So, and I saw another question, and a lot of these questions dovetail off of what are your ADA requirements? What information are you allowed to gather about your employees? I think in the chat, there's a couple questions about taking employees' temperatures, right? And so normally when somebody calls out sick, you shouldn't ask for a whole lot of detail about why that person's out sick, but the EOC has issued guidance in the light of the pandemic where if somebody is out sick, I think you can ask, what symptoms are you experiencing? I think you can ask whether or not they've had a diagnosis. We've been asking a lot of clients whether or not they've tested positive or have received a test. Now, I think it's an open question right now whether you can require an employee to take a COVID-19 test. I don't think you can go that far, but I think you can say, have you had a diagnosis? Have you been around someone who's been diagnosed? Have you been around somebody with symptoms? All of those questions follow very closely the CDC's guidelines for employers, and the EOC has kind of defaulted to them. So normally you wouldn't be able to ask a whole lot of these questions if not for the fact that this is a pandemic and the CDC is advising you that you can. I would, on the temperature taking issue, having a lot of clients take employees' temperatures, the one thing I will say as a caveat to that is that temperature isn't the be all end all, right? So I think you can take in temperatures, and in fact, the EOC's guidance says you can take temperatures because it's a risk issue. All the other employees who might be exposed to that person are at risk, and you have a duty to those employees, both under the ADA and all these other, most federal legislation, also under OSHA's laws. You have a duty of care for your employees. So I think you can take the temperature. The EOC does caution, though, in its guidance that the temperature, whether or not somebody has a fever, doesn't necessarily mean that they have COVID-19. Also, whether or not somebody doesn't have a temperature doesn't mean that they don't have COVID-19. So it isn't a surefire way of determining whether or not somebody has has coronavirus, but excuse me, it is a way that you can at least begin to look at the issue, and I think it's acceptable at this point.
Yeah, I think from everything that I've read, HIPAA, ADA, they all apply. So if you're asking these questions of the employees, it's still protected health information.
That's right. And we talked about that last week, but I should have mentioned it. Your normal obligations not to share that information still apply. Now, another situation that has come up quite frequently is you have somebody who calls out sick. You are able to determine either that they're showing symptoms of COVID-19 or they have a diagnosis. I had a couple clients who have had diagnoses in the workplace. What do you do? Obviously, you can't share their name or that information out there with your employees en masse, but you also have a duty to let those employees know that they should self-quarantine. You have a duty to other employees that they should self-quarantine. And so if you have somebody who is experiencing symptoms, you have somebody who has a confirmed diagnosis, I think you can ask that person, okay, who are the people who you were in close contact with? Gather that information. Then go to those people, and without revealing the name of the person or any of the specific health information, say to them, look, we've had a report that somebody in the office who you may have had close contact with was either diagnosed or is experiencing symptoms, and we encourage you, if not require you, to go home, telework if necessary, or self-quarantine. That has happened, and clients are doing that. That's I think under the guidance that's out there right now, that you can do that, and you have a duty to protect your other employees from potential exposure.
Okay, so a couple of what might be quicker answers. So one is there anything in the law, the other question actually is, does this apply to nonprofit religious institutions? Does this law apply to them?
Adam?
My understanding is if you're an employer, the law applies to you. There was nothing written that said religious. In fact, I actually think I might have seen something specific that said this applies to nonprofits. So if you employ people, we're done. That's the end of the conversation.
Now
Jeremy,
you may, if
answer?
you're small, you might, these other get out of free, these other like ways to get around it might apply also. But you'd have to look at it case by case.
Does the new law apply to furloughed employees?
Yeah, so we didn't really, maybe the general question is, okay, what's the difference between people who are terminated or laid off and then furloughed? And then we answer the specific question. So terminated employees are just that. They're no longer your employees. They're free to go get another job. They're free to do whatever. They can collect unemployment. And in fact, in most states now, it's much easier to get unemployment right now. It's much quicker. Your employees won't, there's no waiting period in almost every state. You're not going to, the idea of contesting it seems really, employers shouldn't do that, especially if they really don't have a reason to do that. Furloughed employees are technically still your employees, so they are eligible to receive benefits. They can use their leave typically. They can go on reduced schedules. They can dip into part-time. There's a lot of different ways you can massage furloughing. And then the question is, does this law apply to furloughed employees? I think if they're currently your employees, it would apply. However, you'd have to look at the provisions, and this would be a kind of a case-specific way. You'd have to look at, if you reduce people to part-time, then it's an average of how many hours they worked in the prior 2 weeks as to whether or not, or how much pay they get underneath, or how much leave they're entitled to underneath this law. There's a lot of specific analysis that has to go into it. But my general feeling is that furloughed employees are still your employees. They are your employees, so this would apply.
Gotcha. Okay. So next question. Our organization already offers 12 days of sick and 2 weeks of PTO per year. Are you saying the expanded FMLA is on top of our existing leave benefits?
Adam, you want it?
That's exactly what we're saying. This has come up a few times. I don't care how generous you are. I actually have a client who has open leave. They just give it to you. That's a totally separate story, and we can touch on that if we have time later. But I don't care how generous you are. The law was not written for you and your circumstances. The fact is, yes, this is in addition to, you're not allowed to mandate the use of your leave prior to the use of the government leave. The employee can choose to use it if they're in the unpaid period, but you can't mandate it. There are those pay caps as far as how much they're paid under the government's version, whereas your leave is, of course, paid at their normal rate of pay. But right, they get this leave through the Families First Coronavirus Response Act, in addition to anything that you have chosen to provide to them as a corporation.
Good. So, hey, we're at 101. So I appreciate everybody that's sticking with us. It looks like we've only lost a few people due to time constraints. We'll continue to go. I just want to check, Jeremy, Adam, how much time do you have for overtime today?
I can go until about 1:45.
I can only go to 1:30.
Okay. So we've got a number of questions. So I think we'll eat up the majority of your time, Adam, I think. So question about, let's see, amount of information online is a bit overwhelming. Would you be able to point to specific governing body for this new legislation, ideally looking for web links? I'll jump in first because I don't know. I mean, Adam will probably, but rather Jeremy might plug their own blog, but I'll tell you their blog is good. If you go to the Jackson Lewis blog, or if you have an employment attorney that you work with, there's a number of them in the area that have good, like real time, like meaning they're updating them daily, multiple times a day. If they're a national law firm, they have deployed a bunch of people onto this in their specific areas and focus. So I've done a lot of reading on Jackson Lewis, and there's others as well. That's my general answer. Jeremy, Adam.
I won't take offense if you go to another employment lawyer's resources. I will shamelessly say that ours are better, but look, we're national. We have offices in every state, basically, and we dedicated about 80 lawyers to a team who just 24 hours a day, really. I mean, these people are emailing at 3 o'clock in the morning. They are doing this. So, and I did last week give, if anyone who reaches out to me, send me an email or connect with me on LinkedIn, I'll point you to that webpage. Totally free resources, no pressure, no hard sell. And of course, compare it with whatever else you're getting, no problem. But it's being updated really like hourly, and it's really remarkable.
The only thing I will add to that is that this is the document that came from Jackson Lewis. It has not left my desk in like a week and a half. It's marked up, highlighted, dog-eared. The only other thing I would point you to is what Jeremy showed you a little while ago, which was the materials that are coming out on the Department of Labor. Right. And as we said, they're not done. They're still under construction, so to speak. I told you we're supposed to have a labor poster from them today, and we'll see when that comes. So I would say if you have a relationship with an employment attorney, not an attorney, an employment attorney. I don't care how great your attorney is, who helps you with your leases and your contracts. That is not the lawyer you need now. You need an employment attorney, whether it's Jeremy or the man in the moon, you find one. And that's the resource that you go to. And you stick with them through this mess, in addition to using Department of Labor resources. And of course, you may need to assess anything that's being done on a state level. Like I mentioned to you, for example, the DC paid family leave. I mean, that predated coronavirus. We were doing that last summer. But that may be something you would need to look at as it applies over time. So your state, the federal, your employment attorney, there you go.
Right. And if you can't find the Department of Labor guidance, or you can't find the EOC guidance, or just, again, you just contact me. I'll send you that link. That's where we go. So that's where our stuff, that's where we learn about these things. And so I'm happy to give you any of that.
Excellent. Let's see, next question. What are your thoughts on allowing employees who have not received their entire salary, who may not receive their entire salary under the sick and or family leave, to use PTO hours to supplement and create a situation where they can receive their entire salary while on leave? So it's kind of topping up on top of the FMLA benefit.
Yeah, you want to stack it, basically. So I have two thoughts on that. The first thought is related to what I said last week and what I related to what I said earlier today. You need to make sure that your business survives so that you can bring back laid off people, so that furloughed people can return to work, so that people that got pay cuts can be restored to their prior rate of pay. I admire the fact that you want to do right by people and allow them to make their full income, in part between the government funded portion and their stacked on PTO, sick, vacation, whatever. I just caution you, and I know there's a lot of HR people on here, and your job is to look out for the people, but you're part of the business. So I'm going to caution you, before you let more money go out the door, make sure you got enough money coming in the door, right? Like I said before, you take a pay cut, nobody's going to like that. But chances are good that if they're making a certain amount under the law, it's probably paying them more than unemployment. So if you are going to stack on top the paid time that they have in their bank, that they've accrued, however it works where you are, just think, how long can we afford to do that? At what point does it begin to jeopardize the employment of other people and the existence of this firm? Now that's my business answer. My HR answer is, okay, yeah, I like that, right? And obviously if a big chunk of their pay is getting paid by the government, that does lower your cost burden, and that's great. And most people, it's unfortunate, but we all live in our means, some people beyond our means, but if I'm making $80,000, I'm spending $80,000. And oh my God, I'm only making 70, what am I gonna do? Well, I would say tighten your belt and figure out how to survive without a few more, steak dinners. But the fact of the matter is, some people may need that full 80. And if you want to help them earn that by supplementing with their PTO, just think it through entirely.
Yeah, I think so. Like the FMLA is largely, not largely, but what you can do, what employees can do with their own accrued leave is largely permissive. And so if an employee wants to supplement by taking down their leave and you're okay with that, I don't think there's an issue with that practice. I think you can do that. We've been advising some clients, but Adam is right. You should look at your circumstances. A lot of this can be boiled down to business decisions. So again, I think it's a case by case thing, but that is an option that's out there.
Let's see. Per our governor's advice, we are now taking employees' temperatures upon arrival at work. We have had to send 3 employees home due to fevers. We are keeping them out of the shop for 72 hours. I know that the FFCRA is not retroactive. If an employee is instructed to do a 14-day quarantine by their doctor, can they take the additional 14 days when the new law goes into effect? Or can the PSL be taken as partial time?
I think if they get a doctor's order that says that they have to quarantine, that this law would apply to them. That's bullet one. I think under the law is you have a diagnosis and you've been ordered by a healthcare provider that you need to quarantine. That qualifies for it. The circumstance under whether or not that's somehow mitigated by prior use of leave given a high temperature, honestly, I probably wouldn't want to mess with the law. When you have a diagnosis, that's a kind of to say this person whose doctor says you have to be in quarantine for 14 days. Well, you really took 3 days before this, and you can only be quarantined 11 days, contrary to what the doctor is saying. And not get paid. I think that would be unnecessarily prohibitive and a potential risk.
So tread cautiously.
Yes.
As a small business with 25 employees, FMLA doesn't normally apply with us. With this new legislation, does the 4, 5, and 6 statements of paid family leave status still apply to our employee base?
So, yes, I think so.
This goes back to if the DOL relaxes guidelines, right? So it encompasses everybody from
it does. Literally any employer with 500 or less employees, or under 500 employees, that's what we're talking about here. Now, there's potential for regulation that would exempt certain small businesses under a certain threshold. Those regulations haven't come out yet. When they do, you want to take a look at them and then kind of analyze whether or not you meet that exception. There are other options, though. I think you're stuck with it. It's a really unfortunate situation, I think, for very small businesses. It's a law that you would think would apply to, say, employers with 100 employees or more, right? Your assumption would be that those are the employers who could bear this expense relatively safely. But I think the aim of Congress was that employers with 500 or less is basically like a huge percentage of the workforce, just a huge percentage of the workforce, and they're trying to help as many regular folks as they possibly can.
I think you've answered this, so this might be a quick up and down. How does this impact employers who offer unlimited or flexible PTO? Would a separate bucket of leave hours need to be established? I think, Adam, you might have addressed this, but if you want to have a quick, succinct.
Yes, with my client who has open PTO, we suggested to them that they create the 2 different codes, one for family, one for personal, under the 6 reasons, 3 are one, 3 are the other, so that they can say to the government, this amount of money was spent for this covered reason, and we can get that amount of tax benefit back. So they can still take their time off for other reasons unrelated to COVID under your corporate open PTO. But I would create brand new timekeeping leave codes. I've put up a slide about that. Utilize them for the duration of the crisis. This law sunsets December 31st of this year. I would anticipate using it for the remainder of the year, even though you may not use it a lot after the summer. So what? It's still there. That's how I would break it out, because you're not getting reimbursed for your normal PTO reasons. You're getting used for COVID. You're getting reimbursed for COVID-19 leave used reasons.
Let's see. Are there any provisions for parents who have a permanently disabled child over 18 who have lost their daycare facility care under FMLA?
That's a good question. I'm not aware of anything. That's perhaps a very unfortunate, a very unfortunate, they left that out. Unfortunately, it sounds like that's a situation where would normally be covered.
Can I ask a question? So Jeremy, item number 4 on the list says the employee is caring for an individual who's subject to an order as described in some paragraph 1, which is subject to federal, state, or local quarantine, or has been advised as described in paragraph 2, which is self-quarantine. So that to me means if that child had medical reasons, they'd be covered. But I have to agree, I didn't see anything anywhere else indicating over 18,
right,
unable to care for themselves. That seems like it would be a reasonable addition, but I don't remember reading that.
Right. So, okay. Normally, FMLA, you can take care of a family member who is ill, regardless of age. If there's a qualifying event, they have a qualifying illness, and that's normally totally covered. I think the issue that we're talking about here is, does a person who's severely disabled over 18 meet situation 5, and which is where the schools are closed, or the daycare provider is closed? On the letter of it, I don't think so. However, you bring up an interesting point. If there's an individual in your family who is a member of a population which would be, susceptible to these things, you probably could go to a doctor and get some kind of documentation that says that this person needs to be quarantined. Again, though I'm not a doctor, obviously. I also don't know, and it seems like a doctor's note saying something like this person that you're caring for is a member of a vulnerable population and they should be quarantined as a result of that would hit that requirement probably. Not looking at it with more specifics, but that seems okay. But at least as far as the care goes, the care aspect of the daycare or the school closure aspect of it, I don't think that's exactly in line. But yeah, I mean, that's my thought about that.
Now I go back to what I said earlier about this is a time for flexibility, adaptability, and creativity. And if somebody had a 24-year-old child, I would of course say they're not a child. What are you kidding me? And then they said, oh, well, no, they're permanently disabled. They're unable to care for themselves. They're usually in daycare all day. As an employer, I would look at that and I would say, okay, letter of the law, as Jeremy said, no, doesn't apply. Spirit of the law. I'm not the lawyer. He is. It's not in the paperwork, so we're trying to interpret. But as an employer, you can do what you want. I would probably say, give them a break.
As a human, yes, I would definitely say that.
Yeah.
I know lawyers, we don't think of us as humans. We're typically not thought of as human, but the human side of me says, yes, that is correct. I mean, there are a lot of my clients, not absent this situation in particular, a lot of my clients offer FMLA protected leave to their employees, even though FMLA doesn't apply to them. That is not uncommon. There's small employers who say, yeah, we're gonna fill out the form even though it doesn't apply to us, and we're gonna give them protected leave, and they do that. That is not uncommon. So that sort of flexibility, sure, on the employer level could happen.
Let's see. So this is related to something that I was talking about earlier when I was doing my opening comment. So have 125 guidelines been relaxed due to COVID-19? Can furloughed or active employees change their FSA or dependent care FSA deferral amount? So kind of succinctly, on the dependent care side, yes, if there's been a material change in the need for childcare or the availability, the number of hours, the facilities are closed, yeah, that's always been a qualifying event. COVID-19 doesn't necessarily supersede that or make it easier. It was always kind of there. It doesn't get utilized very often because we don't run into these situations until things like this occur. Regarding the FSA, when you say FSA, I believe you're talking about medical because you call out dependent separately. We were talking about this on our call this morning. I don't have documentation to cite this, but the understanding from one of my colleagues is that If it's a furloughed employee, they would not be able to continue to contribute because they're not receiving funds. They would have use of whatever funds are there, and then when they come back, assuming they come back to work, then whatever election was made for that year would then be recalculated based upon the number of pay periods that are left in the year, and then they would continue to have that amount deducted going forward. I don't have a resource on this. My colleague was referring to this, so I'll try to find that and provide it out to you. I did provide a link in the comments, or actually I will provide a link on the reference to Dependent Care FSA in the follow-up email today. I don't know that I'll have an answer on the medical side unless Adam, you have a link to that. I don't know if you do. I'll take it as an action and distribute it to the group here.
The dependent care, I'm totally in sync with you, but I don't have a go-to resource on the medical side.
Yeah, I'm efforting that. So let's see this.
I'll just say, John, on that, I'm not a benefits lawyer, although our firm does have many of them. I have seen some articles recently that talk about some of these issues, about new qualifying events. Admittedly, I haven't had time to read those because it's not my practice, and I haven't had a client specifically ask me. But if, again, I'm going to put my email in the chat, you email me, I'll forward you to that, what I've seen. I don't know if it's directly applicable to this. There's a couple of benefits questions in the Q&A too. I'm probably not the best person to answer those, but I can get you to the right person, or I can get you to an article that might get you there.
Let's see. Is the leave required to be taken consecutively? Many of the employees are able to telework, but also caring for children at home due to school closure. Would taking leave a few hours a day to work a reduced schedule apply here?
Can I take the first shot at that one?
Sure.
So I haven't seen anything that addressed intermittent leave the way it is included in the standard FMLA. So that's my first answer to you. My second answer to you is, if we're talking about an exempt employee, remember, exempt employees are not compensated based on quantity or quality of work. So if they've done some work, they get their pay for the day. I also want to sort of flip the script here and say, don't approach this the traditional way, because this is a non-traditional situation. So, I mentioned this last week where, somebody who's in the, parenting space said, we work a few hours in the morning before the kids get up. One parent stays a half day with the kid, the other one works. We have lunch together, then the parents switch duty, and the kids go to bed, and the parents work a bit in the evening. So are you necessarily going to get your 8 hours a day out of everybody? I'm not going to look you in the eye and say you are, because I'd be probably lying to you. But this is the time for adaptability and flexibility and creativity. And so it's fine to go to that person and say, listen, we've got this deadline. We need this thing done. We got to figure out a way, make it happen. That's fine. But if we're just talking about doing the day-to-day job, you need to be a little creative. Now, bringing it back to your question, I have not seen anything that says intermittent FMLA applies here. I haven't seen anything that says, oh, well, the cap is $200 a day and they worked 3 hours, so we're going to give them $112. I haven't seen anything even remotely like that as of this point. Jeremy, your thoughts, sir?
Yeah, there hasn't been anything specific about intermittent use, but I don't know. I think probably your employees might be able to use it. And in fact, I think it feels like that's better for you, right? If an employee is saying, okay, I need to sign off at 3 as opposed to 5 and take care of my kids, because that's how my family situation works. And they're taking intermittent use of this new type of leave. I think you're getting a good bargain there. You're getting 6 or 7 hours out of your employee, and then only 2 hours of this type of leave, this specific type of leave. You're getting more productivity than you would otherwise be if they just decided, okay, I'm taking 10 weeks of this thing, right? At a lower salary, right? And also benefits your employees because they're going to get the benefit of their full salary. I don't see that as a bad thing. I think that's probably a good way to work with your employees to make sure you manage it.
Here's a question that's a little different. If you close a business temporarily, do you have to pay exempt employees if they are full weeks in which they perform no work?
Well,
Full work, full week in which they perform no work. My understanding is that's the key term. If they perform no work during the week, they can get no pay. But I will caution my own words by saying for a closing occasioned by the employer, the employee can't be penalized for that. But I think that applies like if you had a snowstorm and you closed your shop for 2 days, your exempt people would still get their full week's work. But where there's a full week of nothing done because you closed the shop the entire week, I think that no pay at all is allowed then. Am I interpreting that right, my friend?
I think that's right. And I'm not sure what closure means in this context. Does closure mean, and closure temporarily could mean a bunch of different things. It could mean we're closing just for this week, like we're going to go on and off weeks here, weeks there, or we're going to adapt to whatever our governor is saying, right? Or does closure mean, okay, we think the coronavirus situation is going to be over in 3 months. We're going to close for 3 months. If you're in that situation, you got to have a conversation about whether or not you're technically furloughing your employees or you're letting them go entirely. If you're letting your employees go entirely, you don't have to pay them. I mean, other than obligations that you would have otherwise, accrued leave under state law, you'd have to have, all those considerations, but that's as if you're terminating them anyway. So if they're not working, they're not getting paid. If you're doing like a week or a couple days here and there and nobody is working, then no, you don't have to pay for that piece, but it's got to be, I want to know what temporarily means. Because if you're then closed for a couple months, you're talking about furloughs maybe as opposed to layoffs. But furloughs, you wouldn't be paying your people anyway, but there's still the benefits aspect of it. So there's a lot of wrinkles there.
I'll give you a quick example. Right now the restaurant industry is taking a big hit, right? So Saturday night, my family and I ordered $100 worth of Chinese food. Let me tell you, we had a whole feast going on. And I had to call 3 Chinese restaurants before I found one that was open. The first 2 were closed. And one of them had a voicemail that said, "We're closed for the duration of." Exactly like you said. So in that situation, I don't know anything about this restaurant, of course, but I would say, okay, well, they've closed the doors. They've shuttered the shop for the foreseeable future. I don't know what they told their people, but those are going to be full weeks. If they had any exempt employees, those people would not get paid. Whether they remain as employees at all is subject to the details that Jeremy just put out there for you. Every situation is different, but there you go, right? Can't even get some good, General Tso's chicken right now.
There was several questions that actually related back to another question rather that related back to the dependent care. In the comments, there's a link out to a resource that was talking about dependent care. So you can click on that for further understanding. Basically, it was saying that their dependent care provider was saying it wasn't a qualifying event. So this is a law firm that I found through just searching for this particular answer. I know some providers that do this they're providing it out. Some of the major providers that provide FSA and dependent care are allowing this. Both they're encouraging their employers to understand it, as well as they're providing their own employees the same benefit. So there's a resource for it. Let's see.
Somebody put a question in here about questions you're asking your employees as they come in addition to taking their temperature, which we talked about earlier. Somebody says here they added, have you been to New York in the last week? Have you been to urgent care or the hospital? And then they asked for comments. Yeah, certainly the New York thing seems like new and relevant because the president and the task force said yesterday that they're directing people or, recommending to anyone who's been in New York recently to quarantine for 14 days. That seems like a reasonable question to ask. Also doesn't get at medical information. So there's not a whole lot of things that make my spider sense tingle. The other question is, have you been to urgent care or a hospital? I don't know. I would probably frame it a little bit differently than that. I would tie it to what the CDC says is okay to ask at this point, right? It's not, what if somebody just broke their finger? You don't really care about that, but you should ask, are you experiencing symptoms like this? Have you ever sought medical care for these symptoms? That's more in line, I think, with what the CDC and then the EOC piggybacking on that, on their guidance might say.
I'm going to summarize this question. I think it's related to some comments that I made about furlough, and then kind of dovetails into some of the furlough versus layoff, Jeremy, that you touched on. So what I said was related to furloughed employees. We've seen clients that are allowing, they're still employees. The carriers are allowing furloughed employees, even though by definition of the carrier contracts, it says they need to be full-time employees. ACA says the same thing, 30 hours or more. The carriers are not enforcing that. They're allowing employers, as long as they get, basically the carriers are like, as long as we get paid our premiums, we're going to allow you to keep your employees on our plan. Fully insured, it's already done. Self-insured plans are required to do some language updates, which are pretty simple to do. Talk to your consultant. What we're seeing kind of practically is employers that are furloughing employees are just taking the brunt of the cost of that. Now, if they're laid off, it's a different scenario depending upon your size. They may be extended COBRA, depending upon, this is an area where I'm going to quickly pull back from, but what your severance agreements are. This goes a little bit to what Adam was talking about, and Jeremy might be able to elaborate on this. I know we're running light on time for at least one of them. So anyway, I'll leave it at that. If you guys have things to add.
I mean, if your carrier is allowing you to do something, as a lawyer, I would recommend that you get that permission in writing. You probably want to make sure that it's very clear that, and then confirm that you're going to take some action, whatever action you're going to decide to take based on that guidance. You want to let them know, okay, you told me that this is okay, and I'm going to do it based on your guidance, just so that if there becomes an issue later, you have got something that you can kind of fall back on. But if your carrier is letting you do something, again, there could be other issues, but that seems like you want to cover yourself in that situation the best you can.
Documentation.
Right.
So we are at 1:30. Forgive me. Is that Adam that has to
Give you one more.
Okay. So can you advise on making new hires? We currently have 2 new personnel that are looking to start very soon, within the next 2 to 3 weeks. I understand they will not be eligible to receive the FFCRA paid leave factors. That could be a turnoff for a new hire.
Go ahead, Adam.
Well, as the law says, you have to be employed for 30 days, which is substantially less than under the normal version of the FMLA, right? So if you've got a new hire who's just now joining you, and they get sick, or a family member gets sick, or their kids are out of school, they're not going to qualify for the first 30 days. Now, can they telework? In which case they're working, they don't need the leave. Are they working on site? In which case they're working and they're not utilizing this, right? But if they have an illness that develops after the 30 days, or excuse me, after they start, but prior to the arrival of the 30 days, whether again, it's their own family member, anything is outlined, technically speaking, the law says they're not qualified. Now, as Jeremy said, which I find very insightful and very valuable, a company can choose to be more generous than the law mandates. But, and I'm not a tax guy, I said that before, but let's say you hired an employee and 2 weeks later, their spouse gets sick. And so you say to them, hey, listen, we want you to take care of her, take care of him, be home, no problem, and we're going to pay you. Would the federal government allow you to take the time that you paid them and submit it for your tax refund? Better ask your CPA. I don't know, because officially they would not be eligible under the law, even though you went above and beyond. So again, you got some interesting mix of things here. The law is very clear in that regard. 30 days is 30. You just count it up. There you go. I understand it might be a turnoff to somebody. I don't know what to say to that, because any other job they go to, if the company's under 500, it's the same. And if the company's over 500 employees, this law doesn't apply at all. So, it is what it is. Not that I'm trying to be flippant, but that's the facts. Jeremy?
Yeah, I mean, you can say to that employee, you're not eligible for this type of leave. I mean, it's a kind of a hard thing to say, obviously, in this situation. At that point, also, under most employers' policies, they wouldn't have accrued any leave on their own either. Or very little, right? If we're talking about a week or two, and they accrue that way. Yeah, I mean, it's hard to tell them tough luck, but at the same time, you can offer something. The tax bit issue, I'm not comfortable saying one way or another, but I don't know. I think the government, I'm not sure whether the government would take the position that somebody, like the government is the one who's giving the benefit, or we're giving the benefit, but the government is encouraging the benefit, requiring the benefit. I'm not sure whether the government ultimately will take a position that excludes somebody who had received the benefit, but again, who knows? I just don't know. We're not at tax time yet.
Yeah, I think it would be key to that point, though, is make sure that whatever decision you make, you're making for the company as a whole, not for an individual. Otherwise, you get into a disparate treatment situation, and you just open yourself up. And not that I'm a lawyer, but just be consistent. And this is the policy moving forward. If we're going to provide a greater benefit to this new hire, then provide a greater benefit to all new hires that are coming on board in this window of time between now and the sunset of this law. With that,
I'm gonna jump off. It's been a pleasure. I hope you all survive. Take care and hang in there.
thanks, Adam. We really appreciate your help.
Looks like there's a couple more small ones.
Yeah, if you want to just jump in and answer, that's good.
So one person is asking if we are in Maryland, and apologize, I'm looking at my other screen, so you're not getting to see my pretty face for a couple seconds. If we are in Maryland where paid leave is required, how would you handle this with new COVID sick leave, not additive, right? ? That seems, not exactly sure what not additive means. I think it means it's not in addition to what you're already offering, and that's not true. It is in addition to what you're already offering. So I want to make that part clear again. This is a new category of leave with specific requirements for people to meet. So it is an addition. Is the leave required to be taken consecutively? Many of our employees are able to telework, but are also caring. Oh, we talked about this a little bit. We're taking a leave a few hours a day, work a reduced schedule apply here. I think that's an option, although the law doesn't specifically say anything about intermittent use of COVID-19 FMLA leave. So, but I think that's like I said, if you can do that, it seems like it's a benefit to you and probably a benefit to the employee as well. An exception for healthcare providers and emergency responders. Where can we find out what is covered as emergency responder? Hold on one second. I read that earlier today. Let me just pull that up. Okay, so both provisions of the law, the FMLA and the paid sick leave provision, allow an employer of an employee who is a healthcare provider or an emergency responder to elect to exclude the employee from the application of these two provisions. So that's our summary of it. I would say that if you have somebody who meets those requirements, you can exempt them because obviously they're going to be spending a lot of time away that is required. However, I would look for guidance in the next couple of weeks about that provision. That most of these exclusions are going to have guidance. That's usually the way it works. When there's an exclusion and it's not totally clear, like this isn't all that clear to me, they will issue guidance about it.
So there's a question about, am I saying that employers are extending pay or health insurance to laid off employees? No. Furloughed employees, we've seen this action taken for furloughed employees because there's really no way for the employer to be able to deduct premiums out of their paycheck because they're not getting one. So they're basically taking the brunt of the health insurance premium on for that employee while they're on furlough. Laid off is a different scenario completely. This gets into, and I'll defer to Jeremy on this with respect to severance or separation agreements that this employee may have that could allow continuation. The standard way would just be if you're COBRA eligible. So you have 20 or more employees, then the employee would get, the former employer would get a COBRA notification and they could elect COBRA. Or if you're less than 20 employees, based upon your jurisdiction, you would likely be responsible to provide them some sort of state continuation benefit. which is more like self-administered COBRA. No, I'm not seeing my clients picking up just without some kind of a severance discussion. So I'll defer that to you, Jeremy, to talk about severance.
Yeah, we normally, the way it works usually is if there's severance and that's a consideration that the employee wants put in there, then we reimburse for COBRA premiums. That's usually how it goes. I'll tell you that the insurance companies would have a real problem with you like artificially keeping someone on the rolls when they're not actually working. I don't work at an insurance company, but I know that they would have a problem with that. And you have to report the hour. You have to report the hours, so they're probably going to find out that the person isn't actually working. That's just not a situation I don't think you ever want to be in. I think you just say you're going to know how much the COBRA premium is going to be paid by the employee within 30 days of the time that they're terminated. You're going to know that. So why don't you just offer to reimburse them for that? That's the way to keep it going for whatever period you feel comfortable with.
Yeah. I mean, the former I've seen I've come across companies that have kept somebody on benefits well beyond and not had appropriate like discussions with their carrier about this. It's not the way to go. It's better to reimburse for COBRA. It's cleaner. It's the right way to do it.
I'm going to make a general statement. I don't think there's a question on this, but it's important. When you're laying off people, and this is based on knowing that there's at least some people here who are in like the 50 to 500 range in terms of number of employees. When you lay off a number of employees that exceeds a certain threshold, either in terms of raw number, or you're closing like an office or a facility, or you're letting like at least a third of your workforce go at a specific job site, you need to think about, there's a law called the WARN Act. It's a federal law that requires that you give 60 days notice to employees who you're going to let go as part of either what they call it a plant closing or a mass layoff. Plant closing means facility closure. You really have, there's a lot of analysis that goes into whether or not you have to give WARN notice, and that depends on how many people you have working at a job site, how many people you're letting go, whether or not there's multiple employers at the job site. There's a lot of issues there, and I've answered more WARN questions in the last 2 weeks than I've answered in 5 years of practicing. In the last 5 years, I practiced before that. So if you're talking about mass layoff, 50 or more people, you should reach out to someone who can advise you about that. There's a lot of landmines.
Yeah, and I just popped a link up to that from DOL's website. There's also, and I saw something I don't have access to it like immediately while we're on this, but it's some kind of if you have employees in California, there's like a mini WARN Act in California that I saw. Maybe it was through your blog, your company's blog.
So there's mini WARNs in almost all the states. There's a handful that don't have them, 10, 15 or something that don't have them. So there's both the federal and the state requirement. In California, and this goes to like Adam's point earlier about how quickly these things are shaking out. There's an exception to the federal WARN that's for unforeseen business reasons that you don't have to give the notice to people. And we have been telling clients that this, as long as you can show it as really impacting your business, would meet that exemption, absent circumstances. I mean, we'd have to really look at it, but this is one way you can say, okay, there's no way we could have given 60 days notice because we're closing the whole company down. We had no idea 2 weeks ago that this was even a possibility. California, in its mini WARN, didn't have that exclusion at all. That means that if you close down your business, you had to give 60 days notice or pay your employees 60 days worth of wages in lieu of giving notice, regardless of how crazy the circumstances or how quickly you had to shut your business down. Last week, California nixed that. They put that exemption in their law. They acted really quickly and completely changed their law, given the current climate, right? And California, anyone who knows me has heard me say before, is the craziest place to be an employer, has the weirdest laws, has so many statutes that it just, quite frankly, would be impossible to understand if you didn't have counsel working with you. But California changed its requirement. So that's, things are changing on that front, but that's a law that you need to keep in mind if you're laying off more than, say, 50 people.
So somebody, it's not a question, but it was posted in the questions, and I would love to, if you can, if you're still on, if you can put that into the comments. Don't have the ability to copy and paste for whatever reason out of the Q&A,
Sure.
but the FFCRA poster has been released that Adam was referring to earlier. So if whoever posted, because that's posted anonymously, if you wouldn't mind.
Yeah. Hold on one second. I can pull it up. I saw that comment. I was pleasantly surprised about that. Let's see here.
And then once we post that up, I'll hold open for a few minutes, or for a minute or two, so people can grab that link. And then I think we'll close because we're getting to it's 2 minutes to midnight for you, so to speak.
Yeah, I'm not.
And I think we've gone.
Somebody did post the link. Hold on one second. Let me see if I can find that link in the chat. I think I saw it. Somebody who was.
Yeah, appreciate
Oh yeah,
it.
there we go. Somebody just put thank you.
Awesome.
Participant. It didn't come up on my first Google search, so this is great. But yeah, there it is. So prominently display and distribute that to your employees.
Good. Well, everyone, I really appreciate your time and attendance, and just a large number of people stuck on through the extended overtime. So thanks to Adam. If you happen to jump back on and look at the end of this, thank you, Adam, for your time and energy on this. Jeremy, also really grateful for your time and energy. I know this is part 2. I don't know if there's going to be a part 3. I think we'll sync up and chat after this and see if there's still things that are out there that we want to discuss. I know there's legislation that's pending today. This is more financial side, but I think there'll be some ramifications to employers as well. In closing, like I said, I'll send out the search this afternoon. With that, you'll also get the ability to see this. It is recorded in the cloud, so I'll send a link where you can see that. And I'll provide in those emails contact information. I know Jeremy provided his email address in the comments here. I'll make sure to provide their contact information and any correspondence so that you can reach out to them. And then if you wouldn't mind taking a minute as you're exiting out, just completing the survey, it would be great. We appreciate the feedback. Thank you everyone for your time, attention, and questions. It was very helpful in facilitating this conversation. We look forward to talking with you again. And now I can change out of my home office uniform, and so can Jeremy.
Put my shorts back on.
Exactly. All right. Thanks, everyone. Have a great day. Stay well. Stay physically distant, but socially connected. All right. Take care.
Thank you.